Good?
Okay, it was better before. He moved it a little bit too much.
Oh, okay. Tabby, put it back. Better?
Right there. That's good. Yes.
Okay, cool.
Okay,
All right.
thank you.
No problem.
Seat, please. Be seated. Please rise. Justices of the Appellate Division, Supreme Court, First Department. Hear ye, hear ye, all persons having business with the Appellate Division. Draw near, give your attendance, and you shall be heard. Please be seated.
Good afternoon, and welcome to the Appellate Division, First Department. Most of you know the way this works. The bench is familiar with your briefs, with the record, and so please only ask for that time that you actually need, not the time that you want, understanding that the clock is for you, not for the court. If the court has more questions, we will continue asking questions beyond the light. And if you do that, then I don't have to make the time adjustment for you. Okay. People versus Suleiman. I'm sorry? Okay. 4 and 2 and 4. And thank you. Park versus Curto Systems. Okay. 5 and 2 and 5. People versus Robert Pruden. Submit. And children. Submit. Sky Coverage versus Al Wex Inc. Counsel? 6 and 1? Okay. Let's do 5 and 1 and 5. Jeter versus Poole. Okay. Okay. 5 and 1, 2 and 5 and 4. Thank you. People versus Daquan King. Okay? 5 and 1 and 5. The questions may take you up to 2 anyway, okay? Gerzak versus Goldfarb.
Appellate Goldfarb, Your Honor, request 5 and 2.
Okay? Is there a cross appeal? Is there a cross appeal?
No.
Then you're not entitled to rebuttal. How much time? The appellant gets rebuttal time. Respondents only get full argument time. Ah, okay, and you're an appellant as well? Okay, so 5 and 2 you said? All right. Okay. Let's do 4 and 2, 4 and 2, and 5. Anonymous versus anonymous. You're hereby, oh, okay. Okay, 5 and 1 and 5. Bumble Trading versus L&L New York 5. Okay. 5 and 1 and 5. Quealy versus AXA Equitable. Oh, that's surprising. Submit. Muser versus Brook, submitted. Marbu Associates versus White, submitted. Crandall versus Equinox Holdings, submitted. State Farm versus All City Families, submitted. First case on the calendar, People versus Jassy Suleiman. You may proceed, counsel.
Good afternoon, Your Honors. My name is Mark Zeno, and I represent Appellant Jassy Suleiman. May it please the Court. The photo array from which complainant identified Mr. Suleiman was unduly suggestive. The complainant's description of the man who'd robbed him had a single distinguishing feature.
Okay, so I looked at the photo array. I mean, of the 6 photos, I think, if I recall, the defendant's photo is the only one with a little bit of a white mark on his shirt.
In writing.
In writing?
Well, he had a white shirt with black.
Oh, it's a black shirt with with a mark on it. Of the 6 photos, he's the only one that has that mark, right?
That's correct.
So it's pretty much like saying, pick me, in a sense, right?
It's
It seems like it's shouting out, like, I'm the guy, pick me.
that's what I'm saying.
That's pretty much
Your
it,
Honor.
right? I mean, it's just looking at the photo array itself.
That's correct. And the officer that composed the photo array knew that was the description. It was a
But
description.
that's what the cab driver said, that's the thing that stood out in his mind.
Right. It was a description of a black man about the same height as he was, wearing a white shirt with a black zigzag design or scribbling on it.
Right.
And if you look at the photo, you have 6 black men in T-shirts, and only one of them has a black scribble-like design.
It's a white scribble. It's a black T-shirt with a white scribble.
No, it's
White-
white with black.
It's white, okay.
White T-shirt.
White with black.
White T-shirt with black scribbling. And the standard is whether the photo identification procedure singles out the suspect for identification. And here, it's the only distinguishing feature that the complainant could describe, and it singles him out. Really nothing more to say than that.
Okay, thank you. Counsel, you have 4 minutes.
Good afternoon, Your Honors. Diana Wang for the People, and may it please the Court. The standard is whether or not the picture itself, under a totality of circumstances, is unduly suggestive.
So let's explore that. You have a victim whose primary focus during this robbery is this distinct white T-shirt with writing on it that he could not identify. It was also 4 o'clock in the morning, so that's understandable. But he was really, really clear. It was one of the major descriptions given of the perpetrator.
Well,
And then this officer puts together this photo array where he shows precisely this distinct T-shirt. So it is like the quintessential example of suggestiveness, counsel.
I disagree, Your Honor. First of all, the victim did not describe it as a white shirt with black writing on it. He said it was a scribble, and he specifically disavowed that it was a word. And from the photo array itself, you can clearly see that it's the letters, it's not a scribbling, and all of the shirts were cut off at the necklines.
Except that it's clear from the photo. Are you really going to stand there and say that the photo array photograph that we have in the record does not display 6 men and only 1 man with a T-shirt that has letters on it?
It does describe a shirt with letters on
I'm glad that
it.
you're willing to concede that because it is blaringly obvious from the photograph.
Your Honor, just because there is a particular piece of clothing that matches the victim's description, this court has not said before that that in itself renders a photo array unduly
So,
suggestive.
counsel, what's confusing to me is how using a computer database of photographs, the people couldn't have, or the police couldn't have picked a better array. I don't
Or crop the
understand it.
picture.
Your Honor, first of all, it is cropped. They're all cropped at the neckline. So for the defendant to
No,
assume...
it could have been cropped just at the head.
But it certainly does not
Easily.
show, it certainly does not show the whole shirt. So for
It doesn't
defense
have
counsel...
to show the full shirt. He's the only one with a shirt with writing. The only one.
I think that actually assumes that the other 3 men wearing white T-shirts had nothing on their shirts, which is
So,
simply not an
counsel,
assumption
we had
you
the
can make.
benefit of looking at the photographs. I mean, this is not speculation. This was the only person who had any type of writing, scribbling, decorative element. That was it?
Yes, and the victim was instructed by the police that the people in this photo array may not appear as they did on the day of the incident. And the police even said that hairstyles and facial hair might
Counsel,
change.
that doesn't help when the person you have in the photo array has the actual shirt on.
But if you look at the actual shirt, Your Honor, if we look at the actual shirt and reach into the trial record, you'll see that it's actually a shirt with a very busy design. So for the victim
And
to
it
say...
is a shirt that had London written across the top.
Except the victim specifically denied that it was a word. He said it was a
Because
scribbling.
several of the letters were on the arms. So there was no way for him to read unless the man did an entire turn in front of him.
I think that actually speaks to what the victim actually noticed about the shirt, which is the shirt itself is a very busy design. It's got the entire Big Ben Tower on the left side. It's
Okay,
got some
was
bus-
there any other shirt in the photo array that had a busy design?
We don't know, Your Honor. So for-
Counsel, in the photograph, is there any showing of any design on any other shirt other than defendant's?
No, Your Honor, but again, we're only looking at the necklines of the shirts. So for defense counsel to come in and say that the other 3 white-shirted men are wearing plain white shirts is an assumption that the victim would not have necessarily made. And the victim, keep in mind, saw this photo array on the same day of the robber, and he was confronted by the robber at knife point
So
during a
let
knife point
me
robbery.
ask you, counsel, how do you distinguish this case from People v. Perry?
I'm sorry, People versus Perry?
Yes, where the only person in the photo array had an eye patch.
Your Honor, I think an eye patch is far more distinctive and identifies far fewer people in the general population than a white shirt with a general design description on it. Keep in mind, the victim did not say that it was writing or that it was a word. He said it's not a word, it's not a word, it's not a common logo, it's just some sort of design. And if you look at the whole shirt itself, you'll see that the victim probably went to the most eye-catching part of the shirt, which is not what's on the neckline, but simply the large black and gray and white and red graphics on the entirety of
Didn't
the
he
shirt.
say at the hearing that he was fixated on the unusual shirt that the
Your Honor, I like to
perpetrator
actually...
was wearing?
Yes, I appreciate the opportunity to address that. That testimony came out when defense counsel specifically asked the detective, did the victim say anything about his footwear? Did he say anything about his hats? Did he say anything about his pants? And the officer responded, no, he was fixated on the shirt itself, which to me, put in context, means the detective was answering the question that the victim did not say anything more specific about pants or shoes or hats.
And to me, all that did was highlight, we better cover up that shirt in the photo array so he doesn't pick the shirt.
Your Honor, I think the standard is to look at the totality of the circumstances.
And I am.
when you look at the fact that the victim viewed it just hours after the crime happened, when you look at the standard instructions that were given to the victim, when you look at the fact that there was no intentional bias introduced here by the use of a computer software, I think that there is no undue suggestiveness after you look at all of these factors.
Thank you. Counsel, you have 2 minutes.
Your Honor, I think the court understands my point. Unless you have any questions, I'll waive my rebuttal.
Thank you so much.
Thank you.
Park versus Curto Systems. You may proceed.
Thank you, Your Honor. Good afternoon. Seth Rafkin for the plaintiff appellant, Carol Park. I know the court's familiar with the record. A couple of points that I wanted to stress. I don't think there's a huge legal issue here, but I do think it's important to reflect on the standard of pretext in this employment matter. As this court has held, evidence of pretext should, in almost every case.
Well, what evidence of pretext are you referring to? Because what I have reviewed is concrete facts concerning performance or lack thereof that have not been contradicted. So what am I missing?
I think what you're missing is comparing it to the disparate treatment. So there is a square comparator here, a male sales representative peer to the plaintiff. That's Mr. Perlman.
Are they equal?
They are. The respondents.
I don't think so. We have one person who has your client had almost double the salary, and that double salary was based on her extensive sales experience. And so is it not fitting that someone who makes $45,000 more than the gentleman you're talking about, who has extensive experience in this field, should not the company expect more from her?
Your Honor, when you look at these comparators, the respondent admitted in their statement of facts that their positions are substantially similar. And that's what you have to look at, is what does the position require? The male comparator was there far longer than our client. He had a shorter sales cycle for the accounts he managed.
And he did exponentially better.
No, no, that's the point. He made no sales. His performance was identical to my client's.
I don't think that you can exactly say that, counsel. If you take a look at what the performance improvement plan sought of the plaintiff, she was expected to make 40 cold calls, 25 supporting emails, and then 1 qualified pipeline per week. But she instead did 20 to 30 calls and or emails with prospective customers, and had not one sale in all of that time. So she was an executive, wasn't she?
No, they're both sales executives. So you've got a male, you have a male who is there longer in the same position.
Wasn't she hired as a director of enterprise?
Correct, there's 3 different types of accounts: enterprise, strategic, and mid-level. The male peer.
And wasn't Mr. Perlman mid-market, mid-level?
Correct.
So
well, the accounts he goes after are.
He handled enterprise sales.
Correct.
Which is to say sales targeted to large businesses.
Correct.
He handled mid-market sales with lower expectations, right?
Well, and a shorter sales cycle. So her sales cycle, the company told her, is 6 months to a year, because it's a larger company. Larger companies, more procurement to go through. She's not even there for 6 months. She makes 0 sales in a shorter period in which her male comparator that they say has the same position He's there for longer, never makes a sale. In fact, all through the rest of that year, he never makes a sale. He's not put on a performance improvement plan. She is. He's allowed to go to the company's specific sales training in London to know how to sell their products. She is not. She has complained to Human Resources about, among other things, the COO of the company taking young women's phones, going through them, talking about their Tinder profiles. She complains about that. She complains about the fact that she doesn't get, that she hasn't received the same SDR support.
So I tried understanding the whole tinderbox thing, right?
Yes?
Did he take her phone?
No.
Okay, so is she asserting a claim for them?
She observed the COO of the company taking the phone of two young women at the company, et cetera, about Tinder. Those women told her it made them uncomfortable. That's one of the things that she complained to Human Resources about. The next day, after she complains to Human Resources, they contact a recruiter to replace her. 4 days later, they put her on a performance improvement plan, despite the undisputed fact that there has been no performance feedback beforehand. She's got a male peer who has the same level of performance, never made a sale, never even made a sale in the 5 months left in the year after she left, after she was fired. That is pretext. They didn't give her a chance to finish the performance plan. It says nothing about your employment will be terminated. It doesn't say you have to make a sale. It says you have to beef up your pipeline, which she does. He ignores it. The manager testified that he didn't look at her pipeline.
Didn't Mr. Perlman, her purported comparator in your eyes, have 211 activities, sales activities within his first 7 months? Mind you, it's longer, as opposed to her 11 activities, I mean, in 5 months? Isn't that a problem?
I don't think it's a problem because, again, then it should have been, number one, I think it's disputed as to the level of her activity, and that gets into this whole issue of this Google document versus the Salesforce. She says that she maintained her activity in a Google document that Abramson said that's fine, but then they say, well, when we go and look at Salesforce, we don't see your activity. And she's saying, I told you I wanted to do it in Google Docs, and you said that was fine. And that's the piece that he says he didn't even look at when he comes to that end of forecast.
All right, you'll have 2 minutes on rebuttal.
Thank you, Your Honor.
You may proceed.
Good afternoon, Your Honors. Mike Frankel from Jackson Lewis, representing the respondents.
Was she given enough time?
Yes, Your Honor. So Ms. Park, first of all, was an at-will employee. She could have been terminated at any point for any reason. She was an expensive resource, as Your Honors noted. She had prior sales experience. She was provided 5 months to provide sales, and not only to provide sales, to have a viable pipeline. So not only did she didn't have any sales, as Mr. Abramson told her at her termination, he didn't see any viable opportunities in her pipeline where she would have foreseeable sales in the future. So they would have continued to employ her for months on end with still no sales, yet still paying her a 6-figure salary. As Your Honor noted, the distinction with Mr. Perlman is that he also had no sales, but he was hired in an entry-level position as a sales development representative.
How do you explain the fact that one day after making her complaint, there was an outreach to replace her?
So at that time, Ms. Park's 90-day performance evaluation, 90-day probationary period had expired. That's why she was placed on a PIP, and they had explored potentially replacing her. It wasn't decided at that point in time yet.
So you're saying that the call to potentially replace her was coincidentally the day after she files a complaint?
Yes, Your Honor.
Counsel? That is like a real stretch.
I think the issue, Your Honor, is that her complaint was a verbal complaint to HR. And it is disputed.
And where else should she have made that complaint other than HR?
That's perfectly fine. There is a dispute with HR about what was said. We take her version as true for purposes of our summary judgment motion. But it's undisputed that Mr. Abramson had no knowledge of what Ms. Park complained about. The only knowledge Mr. Abramson had was that Ms. Park complained.
Well, other than him saying he didn't know, what other proof do we have that he didn't know?
There's no other proof anywhere in the
Does
record. that-
HR say that they didn't tell him? Do I have a statement? Maybe I missed it in the record.
There's not a statement from HR, there's only a statement
So I have to
from-
rely on him
On him,
for
Your
that
Honor.
statement.
But also, Your Honor, we can rely upon, we submitted as a business record HR's notes of the conversation with Ms. Park. In HR's notes of the conversation, there's only a reference to her complaining about this, her being excluded from an event called Trendy Pants Day, where people.
I'm sorry, is there a dispute that she was not included on the training trip to Europe? Is there a dispute about that?
There's not a dispute, Your Honor, because at that.
So then it's not just about the trendy pants party, is it?
Well, no, because at that point in time, Your Honor, she was already let go. At the point in time of that trip, her employment was already terminated.
So you're saying there was no training programs at all for any of the employees doing sales during her tenure that she was not included in? Is that what you're saying?
Mr. Abramson testified, Your Honor, that he met one-on-one with all of the sales
That doesn't
representatives.
answer my question. My question, in case you missed it,
Yes.
was, are you saying that there was no training programs that other salespeople, other sales employees were invited and included on, but she wasn't during her tenure?
Correct. There was no formal training program. The first formal training was that July training program.
Talk to me about the informal ones since you put a caveat on my question.
What the evidence on the record is, Your Honor, is that the head of sales, Mr. Abramson, had regular meetings with salespeople, not formal, but they all worked in a small office. So if there was questions, he certainly met with the salespeople, but Ms. Park was an experienced salesperson, which is why she was paid a six-figure salary.
Yes, but she now moved from one industry to another. And it takes time to switch over and develop the kind of contacts you need to create the pipeline that you're talking about in a new industry. So was she afforded enough time to utilize her skills in this new field?
Yes, Your Honor. She was actually afforded the same amount of time as the person who assumed her position, Joe Powers, was. She was afforded 5 months to have any sales. So was he when he assumed the enterprise director position. He was also let go for lack of sales within a 5-month period of time. So she was treated in the exact same manner as a subsequent male employee was. And Mr. Perlman, who was also let go or was asked to leave essentially for his poor performance after a year of being in the job.
Okay, thank you.
Thank you, Your Honors.
Counsel, you have 2 minutes.
Thank you, Your Honor. Just quickly on the issue of training, to be clear, there really are two different training opportunities. One is the conferences that is part of what she complained about to HR, saying the male sales folks are being encouraged and allowed to attend conferences that are important.
So I just asked your adversary a question whether there was any formal trainings that she was excluded from, and he seemed to indicate that those trainings happened after she was fired. Is he wrong?
Well, yes, in terms of the conferences that I'm talking about, those are before. There was a training.
Those are before she was fired.
Correct. And then there is the one that he is referring to. He's correct that there was a formal training in London after she was fired, but the timing is very important. That training occurs during the period of this purported performance improvement plan, and rather than let her go, get the training which Mr. Gelman testified would help her meet the objectives of the performance improvement plan, instead they say, you can't go, and we're terminating you. So those are two distinct training points. That's all I wanted to clarify. Thank you very much.
Thank you so much. Sky Coverage versus Alwex Inc. You may proceed.
Good morning. My name is Robert Fass with Goldsmith and Fass, co-counsel with Heldon Hines for Appellant. I'd like to address the issue of whether the escrow that had been established in this case to preserve the status quo should have been set aside because this court dismissed our rescission action. And the answer is it shouldn't. The basis for that escrow is that there was evidence that the non-disparagement provisions of the underlying contract, which was a settlement agreement, had been breached. By dismissing the rescission action, that does not leave the appellant without a remedy, a legal remedy. An essential element of a breach of contract claim is that the contract has been performed and has not been breached. Here, there's evidence that it was breached numerous times. Now, in the ordinary case, would be, if money is owed under a contract, a counterclaim and an affirmative defense, which would raise the defense that the contract wasn't performed. Here, there's no counterclaim. Instead, the respondent is relying on a provision of the contract that allows the entry of a judgment, which is going to create additional litigation, because if that's done, we're going to have to immediately challenge the entry of judgment. That's pointless. Let it all be resolved in one case. And that leads us to the question of whether the complaint should be amended to assert.
I'm glad you got to that point, because I was on the panel for the last appeal, and this court clearly said that the court should have granted defendant's motion for summary judgment dismissing the claim, as plaintiffs are not entitled to rescission of the settlement agreement. Plaintiffs have an adequate remedy at law. And after this court issued that decision, your client decided to seek an order from the court below to add that claim.
It's really a
So what part of this court's decision was unclear?
Our defense is not equitable in nature. It's an element of a cause of action for breach of contract. We still have a contract claim, and there is no counter.
Did you appeal this court's order?
On the rescission?
Yes.
Yes, but as I said, rescission's irrelevant. It has
Yet you moved to amend to add the claim again after we dismissed it.
No, it's not a rescission claim. It's a claim that because the respondent breached the contract, they're not entitled to enforce the contract. That's a legal remedy. It is not an equitable remedy. And that's why we want to
Did you call it a rescission claim in your motion to amend?
Absolutely not. We called it a declaratory judgment action, and that's what it is. And if you look at the action, all it does is seek to bar the enforcement of the contract, including the last payment and the entry of the judgment. It has nothing to do with rescission. The contract still exists. It's a question of whether it can be enforced, and that's it.
Okay. I'm not buying, but go ahead.
That's pretty much it.
I'm not
No,
buying,
wait.
but you can go ahead.
How is that different from, this is Judge Scarpula. That makes zero sense to me. How is that different from your breach of contract claim? If you claim they breached the contract, then you don't have any obligation to perform under it. And you've pled that, right? What else do you need? Why? This is literally, it is what you are seeking is exactly what one would seek in a rescission claim. Let's be real. You don't want to perform under the contract. You want the contract to go away. If what you're saying is the other side breached, then that's covered in your breach of contract claim, and you don't need it either way.
Well, that's our breach of contract claim, where we're seeking damages. Now, the respondent is seeking damages in the form of basically what's a non-payment action.
You've denied that you breached the contract. So again, I'm not really sure why you think this claim is anything other than you're trying to re-put in a rescission claim that was dismissed. Because everything that you are seeking, and you're telling us here that you are seeking, is covered in your breach and their breach of contract claims. So what is new that isn't?
Well, if Your Honor is right, then the escrow should be maintained. Because for the same reasons you just stated, the contract is unenforceable.
Why would we maintain the escrow? Normally, one does not get a pre-judgment attachment like that in a breach of contract claim. Why would we do that?
because of the unusual situation where there's no counterclaim.
What's so unusual about this situation? Two companies are fighting over business. That's in our court pretty usual, right?
Well, if the
So what's
escrow,
unusual about this?
if the escrow is set aside, we will certainly not make the payment. And what will happen? They'll enter a confession of judgment. And if they enter a confession of judgment, the litigation will continue ad nauseum. We're going to have to oppose it on the basis that we've raised the breach question as a defense, which Your Honor believes we've done. I'm not sure that it's clear, and that's why we're doing the declaratory judgment action, to make sure that it's clear that we've raised that defense. And that's what it is. It's in lieu of an affirmative defense because no counterclaim was brought. It's not a rescission. It's an affirmative defense. It's a matter of law. So what I'm trying to do is avoid the unnecessary litigation of having to go after the confession of judgment when we refuse to make the payment on the basis that the contract has been breached. Unless the other respondent tells me they're not going to enter the judgment, in which case it renders it moot. Also, as far as timing is concerned, this case has been, was originally scheduled for trial much earlier. It was adjourned to December, and then this court struck the note of issue. So
Well, everybody, no, this court struck it. You all asked for it.
that's right.
It
That's
wasn't,
right.
it wasn't
And
like
we
we said one day, oh, gee, let's do that. You
Yeah,
both asked the court
that's
to
right.
strike the note of
It
issue.
was a joint application.
Because in this 4-year-old case, you still haven't managed to take depositions.
Well, COVID had something to do with that.
COVID has nothing to do with that. That has to do with counsel refusing to move forward on court-ordered discovery, okay? But you have time on rebuttal.
Okay, thank you, Your Honor.
Thank you. In the same way that this court and every other court in this state has continued to operate during the pandemic through electronic means, so can depositions be taken. So this court is not going to hear that kind of ridiculous argument that discovery cannot be completed because of COVID. Okay? You may proceed.
Thank you, Your Honor. I probably should just be quiet and move on, but I will make my argument anyway. Regarding the escrow order, it is the fact that the escrow was created to hold the final settlement payment. That's on record page 243 and 246. Those are the stipulations that put it there. They were put there, it was agreed by plaintiff to put it into escrow in an agreement to hold off on a prejudgment attachment motion so the parties could mediate. The parties mediated, it didn't resolve. The plaintiff resubmitted the motion for a prejudgment attachment. And at that point, the court denied the motion and then held on to the money. And the only thing we could think of for why he held on to the money was because it was to secure a rescission judgment. It couldn't have been a prejudgment attachment because in the same order, he denied the motion for a prejudgment attachment. So with the rescission claim gone, the basis for that money to be held in escrow is gone, and it should be released to us because that's what the original agreement between the parties was.
So are you saying if there is a breach of a stipulation, that breach being no disparaging remarks?
I'm not saying there was a breach of that stipulation. The court overrode the stipulation to keep that money in escrow. There's no stipulation as to non-disparagement. There's a non-disparagement clause in the settlement agreement, and there was a non-disparagement injunction entered at the end of the prior litigation without any findings or any opposition allowed, or even
I understand, but what brought this settled case back to court was your adversary's allegation that your client breached the stipulation of settlement by disparaging them.
which hasn't been adjudicated yet.
I understand, but
Right.
it's, I mean, let's not pretend that that allegation is not out there.
No, the allegation is out there, and they they made a claim for rescission. We brought it here. The court unanimously held that it wasn't available, and that holding has
Because
consequences.
we held that if they are successful, they have money damages that they can seek.
And they can seek that at trial or on summary judgment.
Right.
And that, the concern that there's some continuing risk, well, that gets resolved at trial as well. Any judgment or verdict at summary judgment or trial will create res judicata or collateral estoppel, depending on the issue. And then we'll know exactly what the non-disparagement term of the contract means. And we'll know exactly what conduct violates it or doesn't violate it. And the idea that...
I think these clients know what that means now. That they choose to ignore it is another matter, but don't talk nasty about your adversary is kind of a really basic, fundamental, just a human thing, right?
There were real disputes about conduct on both sides.
I understand that, and so I recognize that your client may have some residual hard feelings, okay?
They both
about
do.
what happened here.
Indeed.
But if you reach an agreement where you agree not to disparage the other side, then just move forward, go after your business, and honor the agreements you make.
If you'd like to get into the underlying facts, the main disparagements that they are alleging is that our client went to the carrier, the insurance carriers, and said these broker of record forms to change the broker of record were submitted fraudulently, and they were. There's no way to dance around that issue. They have a client that wants them to be their insurance carrier, and the other side is submitting a form changing it. They have to take that position with the carrier. They have to say, this form was not properly submitted, it wasn't authorized, and we need to do something about it, because they have a common interest in serving their client. And if that is disparagement under the term of this contractual agreement, then the court will decide that.
Got
if
it.
it's not, then they won't. But the primary defense in this case is that every act of alleged disparagement was in response to some misconduct by plaintiff after the signing of the settlement agreement.
Okay. Anything else? In your 14 seconds?
My 14 seconds, if I could just address the, not the motion to amend, because I think it's pretty clear that declaratory judgment is not appropriate in this case on issues that are basically part of the trial. But on their motion for a declaratory judgment, I just want to say that it's not a recognized procedure under the CPLR, which authorizes motions for summary judgment, default, whatever other accelerated judgment. But CPLR 30,001 doesn't authorize a motion for a declaratory judgment. And Siegels says in section 438, if there are issues of fact, the trial is necessary. If not, summary judgment is permissible. There's no such thing as a motion for a declaratory judgment.
Thank you so much.
Thank you, Your Honor.
Okay. Counsel, you have a minute on rebuttal.
Just one quick point, Your Honor. In the escrow agreement, there is absolutely no agreement that if the escrow is set aside, we have to pay the money over to the respondent. And it will not be paid, which will lead to additional litigation unless it is clear that the issue of whether they can enforce their contract, not we can enforce ours, is at issue. If it's at issue, fine. Then declaratory judgment is, as the court seems to argue, is not necessary. But that means that they shouldn't be entering the confession of judgment. And that should all be decided at trial, including the final determination of what defamation means and whether it occurred. That will all happen at trial. But what I'm trying to do is prevent further litigation.
Well, that's not going to happen here, but I'm glad you're trying. Okay? Thank you.
Have a good
All right. Have a good day. All right. Matter of Shanae Jeter versus Sheila Poole. Let's wait for everybody to take their place. You may proceed.
Thank you. Good afternoon, Your Honors, and may it please the court. My name is Carolyn Kubitschek, and I represent the petitioner Shani Jeter, who, having already won her child neglect case in the family court, seeks to have her name cleared in the state.
Now, when you say she won her case in the family court, The case resulted in an ACD, correct?
Yeah, that's correct, yes.
I don't necessarily consider ACD a win on the merits.
Well, Your Honor,
There's been no adjudication on the merits. The court decided that based on this case, it was advisable to adjourn in contemplation of dismissal and required that your client, pursuant to that, stay out of trouble for 6 months, and then the case would be dismissed as a matter of course.
that is
Right?
correct, well, the city, which was the prosecutor, offered that, made the proposal, and all the parties agreed.
Okay.
And it was both to Ms. Jeter and to her husband, Robert Lang, who are both charged, facing exactly the same charges. And the case was dismissed, and under Social Services Law, Section 422(8)B2B, when there has been a dismissal of a case in the family court, and I quote, "There shall be an irrebuttable presumption that said allegation
That's under
has
the
not
new-
been
Counsel,
proven
that's-
by a fair preponderance of the evidence."
There's no retroactive effect here.
Well, that is the issue
statute-
before.
Counsel, please let our judges complete their sentences before you continue, okay? Because we need to be able to hear each other.
Right.
All right? Go ahead.
Counsel, the statute took effect in January of 2022, and here, the fair hearing was in August of 2020. The agency decision was in September of 2020. There's nothing that would indicate that the statute should be afforded retroactive.
Well, Your Honors, in deciding whether or not a statute should be applied retroactively, there are two principles that say that the statute should. Number one, if the statute is remedial, and number
But that is not a slam dunk. That is but one consideration for the court to take into account in determining.
And the other consideration is whether or not it interferes with vested rights of someone else. And the legislature and the commentators have made very clear that the statute was remedial because up until now, there has been a tilted playing field. That is, if the government wins a child neglect case, and then there's a name-clearing hearing for the state central register, the government automatically wins that hearing also. The parent who lost in the family court cannot challenge it. However, up until the remedial laws of 2020 were enacted, if the parent won in the family court, no matter whether it was a win on the merits, a win on...
I'm sorry. Nope. Sorry. The legislative history of this legislation does not support the argument you just made, okay? The entire purpose of this statute, as I read it, is to make sure that where there has not been a finding substantiating maltreatment and abuse, and the case gets dismissed, that then there should be a clearing of the name, and I wholeheartedly agree with that. But that's not what we have here. That is not what we have here. We have a finding that this child was abused, this child was beat with an extension cord, the photographs we all viewed clearly show this was not scratches, the girl had welts on her body, okay? So the entire purpose of this statute seems to me to protect, because there are instances where parents have calls made to the registry against them as a tool to get them, okay? And so I agree that we should have a statute that protects people in that circumstance. But the entire purpose of this statute is not to whitewash someone who has indeed abused the child.
Well,
That's
Your Honor,
not what this is for.
Your Honor, first, there was never any finding by a court that Ms.
No, not
Jeter
by a court,
abused
but
her
they had a
child.
hearing that substantiated these charges.
Secondly, this child went to school on the morning of June 3rd, 2019, with no marks on her body. Sometime in the evening of 2019, she showed up with a friend whom she won't identify at a school, a different school, with marks on her body. And she said, my mother inflicted them yesterday, even though nobody at the child's own school had seen the marks. Yes, there were marks on her body, absolutely. But the mother
And which
did not-
Mr. Lang attempted to accuse the child of inflicting on herself.
Well, Mr. Lang is not a party to this proceeding, but she
Oh,
did
but
accuse-
you told me at the beginning that the
She-
ACD was for both of them,
That's
right?
correct. But his name was cleared because he had a lawyer. Ms. Jeter's name was not cleared. She had no lawyer. The question is still, how did the marks get on the child's body? And Ms.
We
Jeter
will
does
explore, Counsel, you're out of time. I've given you an extra 2 minutes. You have time on rebuttal. We can explore that on your rebuttal time, okay?
Thank you.
All right. Next up. You may proceed.
With Your Honor's permission, I represent the state respondent. During the call of the calendar, the city respondent had said they would take 2 minutes and I would take 5. Is it all right if I go first?
Sure.
May it please the court, Elizabeth Brody for OCFS. This court should confirm OCFS's determination for 2 reasons. First, the decision was supported by substantial evidence, and there is no basis to disturb the agency's credibility determinations on appeal.
What was that substantial evidence?
Substantial evidence included T's multiple consistent statements over a period of several weeks to a police officer, a teacher, and 2 ACS caseworkers during multiple face-to-face interviews. The caseworkers and the police officer observed the injuries on T's body personally, and the teacher, Mrs. Samuel, also assisted the caseworker in observing them about 9 days later. ACS also introduced photographic evidence of T's extensive injuries, as you've mentioned, and there was an emergency room physician's opinion that her injuries were consistent with having been beaten with an extension cord. And I just want to point out briefly that in addition to the caseworker's notes of what the doctor said, the record at 300 to 301 contains a co-signed statement with the physician's signature stating that, quote, T was physically assaulted by her aunt, and, quote, not a safe discharge back to her house, so it seems highly unlikely that the caseworker misunderstood what the doctor was saying.
With respect to the amended statute, do you agree with your friend that the statute, that the amendment is remedial in nature?
We do not. We think that had the legislature intended that the statute be remedial in nature, then it would have gone into effect immediately. Opposing counsel has identified no case in which a statute was deemed remedial, and the legislature set an effective date that was 18 months after the statute went into effect.
But does a remedial statute, I mean, you make that argument as though a remedial statute as a matter of law requires retroactive application, and the case law does not support that. So it seems to me that I'm not hung up on whether it's remedial or not. The issue is whether the legislative intent has any indication that it wanted it to be retroactive. And it seems to me the fact that it was passed in 2020, but specifically did not have an effective date until January 1st, 2022, tells me more about how this is not a statute that requires retroactive application, because nothing would have prevented the legislature from adding those 3 words into the statute.
That's absolutely correct, Your Honor. And as we discussed in our brief, the legislature originally passed a version of this statute that would have immediate effect, and that statute was vetoed by the governor because, among other reasons, there was not enough time to implement the various administrative procedures that would need to occur, including on, for example, the computer database connections.
Well, that and this statute had some imposed upon ACF some really tight timelines in terms of turning around requests made to them, correct? So that if a parent wants to have their finding changed, under the statute, you have like 15, 20 days to respond. It's not a lot of time.
I believe there was I agree with you, Your Honor. I believe there were also timeframes for ACS to respond before when requests for information were made. But I think there are a number of things, particularly when you apply the irrebuttable presumption from family court, there are a number of things that need to happen. Those documents need to be transmitted from family court to OCFS. That needs to be done by ACS. That needs to be entered into connections. There are just a lot of steps that need to happen and a lot of money that was required to be spent to implement these reforms.
Right.
Turning briefly to petitioner's evidentiary issues, these are unpreserved and meritless. This court may not review petitioner's hearsay objections, as she did not raise that challenge below. And because records of CPS caseworkers are admissible by law, as petitioner acknowledges in her brief at 42, and as the ALJ also explained quite clearly to the petitioner. The ALJ also acted well within her discretion in precluding T's undated handwritten retraction. As multiple courts have observed, it is well accepted that recantations are common among abused children, and policy considerations of avoiding re-traumatization and coaching by family members further support excluding these statements.
And did I notice in the record accurately that that statement by the child was neither dated nor signed?
It was neither dated nor notarized. That's right.
Okay.
I see I'm out of time. May I turn briefly to the right to counsel point?
I'll give you 40 seconds.
Okay. It's quite clear under New York law that there is no right to counsel in these types of administrative proceedings, and I just want to stress that the private interests implicated here are far less severe than in other cases where New York courts have recognized such a right, like bodily autonomy in medication over objection cases or medical guardianship proceedings, which are the cases like St. Luke's and Joie that opposing counsel cites. I'd also like to note that in Valmonte, the Second Circuit already expressly held that the petitioner's interest in child rearing is not implicated in the SCR. If there are no further questions, we urge the court to confirm.
Thank you.
Thank you.
Okay. So you have two?
Yes, Your Honor. Rebecca Viscatas for ACS. May it please the court. I don't know that I need the full 2 minutes, Your Honor. As stated in our brief, ACS is not taking a position on the merits of that right to counsel issue. If the court has further questions about substantial evidence, we agree with the state that the evidence presented at the hearing provided a rational basis for OCFS's determination. If the court has further questions about that, I'm happy to address them, and otherwise I can rest on my brief.
Your adversary started by pointing to the dismissal of the case in family court. And as I noted, an ACD is not a dismissal on the merits. Am I incorrect about that?
No, I agree with Your Honor. An ACD in family court requires the consent of ACS and obviously the approval of the judge, and then involves a 6-month period where the parent generally has to comply with ACS supervision and any other requirements and services. And if that is successful, then at the end of the 6 months, the case is dismissed without any determination on the merits, as Your Honor recognizes.
So can I assume that this disposition is one that is utilized perhaps with families that haven't had an extensive history with ACF, that things had been going smoothly up until now, and so it is an attempt by ACF to try to make sure that the family stays intact, that you don't disturb the family dynamics and try to keep this family together, and a ACD assists in doing that by lowering the temperature for everyone, as this child was very concerned, based on the record, that her aunt not get in trouble, that her life would be made worse if the consequences to her aunt were too grave. Have I misread this record?
No, that's exactly right, Your Honor, and that is often the case, that ACS will consent to an ACD not because they don't believe that the neglect or abuse alleged actually occurred, but because there is, of course, an interest in promoting the best interest of the children, which is generally to remain in an intact family whenever they can safely do so.
And lastly, the investigative process of this particular complaint was indeed substantiated, and there was a belief by your agency that this child was indeed abused and mistreated.
Yes, that's absolutely right.
Thank you.
Thank you.
Next. You're here for the amici.
For the amici, yeah.
You may proceed.
Good afternoon, Your Honors. I'm Erin Morgan from Paul Weiss, appearing for the amici in support of the petitioner. We greatly appreciate the court letting us appear today.
You are welcome.
There are 24 amici in this case, including the largest organizations in the state.
I have a question, counsel. The father, the husband here, had counsel at the OCFS proceeding. How did he obtain counsel? Do you know?
My understanding is, although I'm not as familiar with the record as the other lawyers, and I'm sure
Yeah, because you're
they can
arguing that
correct
the
me,
mother here should have had counsel, and I'm just curious to see how the father, I would think they were under similar financial circumstances, how did he end up with counsel?
my understanding is that when there's an appointment at the family court level, that sometimes the counsel at that level are willing to sort of, as a favor or out of generosity, continue on at the ALJ stage. That's not always the case. There's a tremendous scarcity of lawyers to be able to provide counsel at that stage. In fact, in many cases, my understanding from the amici is that the state will reach out to amici and say, can you represent someone in this ALJ proceeding?
And that didn't
But
happen for the mother in
resources are
this
not
case?
always there.
The mother didn't have counsel at the family court level?
She did have counsel at the family court level, but that person chose not to continue on at the ALJ level and has no obligation to.
Okay.
As the attorney who represented Mr. Lang did not have to, he chose. He or she chose to.
That is correct.
Okay.
Or that's my understanding. All of the amici in this case, the amici who represent children, the amici who represent parents, and as I've just said, in some circumstances, even the state, understand that there is a value to having counsel at these proceedings. And that's not just to protect the interest of the parent, it's also to protect the interest of the children, because when there is an erroneous finding and someone is listed on the state central registry incorrectly, it harms the entire family. A SCR fair hearing is a state-initiated proceeding in which there can be an indicated report found of child abuse or neglect. Most of those cases are poverty-related neglect cases.
Counsel, I'm sorry to bother you in the middle of this, but our time is short here. Aren't these really policy points? We're making some very good ones that are really best addressed by the legislature as to whether to fund and under what circumstances counsel in these type of administrative proceedings?
Of course, there are elements of this that are policy-related, and amici do a tremendous amount of advocacy work in that sphere. But when there are constitutional implications, as we assert that there are here.
Well, what is the constitutional, as I read it, because this application is not affecting her ability to continue to be the mother of these children, right?
Mm-hmm.
This is an issue of whether the city and the state should entrust other children to this person, right? So a person who has been found to beat her own kin that she adopted with an extension cord. I mean, that, at the end of the day, that's what we're talking about in this case.
Yes, understood that that's what the facts are in this case. I think the due process issue that we've identified here is not just applicable in this case, it's applicable in all cases. And the due process issue is not saying that it's okay what's been done in any specific case. The issue is that the severity of the consequences of an indicated report are so significant that they implicate the care.
Well, when you say that, I mean, I'm trying to understand the severity. As my colleague points out, the children are not being removed. She can still continue to, I mean, there is no ban on her in terms of continuing to be an adoptive parent or be a foster parent. It may be more difficult, but not impossible, or there's no bar. So I'm trying to understand, where is it in the sense that she loses, if I agree with you, her constitutional rights? I mean, what is it that she's losing? I mean, it's just made it more difficult. She's not making it impossible.
Hypothetically, maybe it's made more difficult, but in Amiki's extensive experience, it is the case that an indicated report has a cascading effect across someone's life. For example, if someone
And
goes
maybe an
to...
Article 78 proceeding that has to be commenced then. Maybe not, this is not the way to do it, right? I mean, if exactly what you just said, perhaps on a record of an Article 78 challenging that kind of result would be more apropos, as my colleague said, because then you're going to have to really flesh out whether or not it's policy or something that we can handle.
That may be true, but this is the opportunity that people have.
Yeah, but it'd be better if it's done on Article 78, where you actually come forward with people that have actually had situations like this, because you can say, and arguably say that they have been deprived of their constitutional rights. That's all.
Understood. Your Honors, I see I'm out of time.
I'll allow you to complete your statement.
I'll just say, this court has repeatedly found that when the state is attempting to intrude on a fundamental right involving family integrity, that New York law requires proactive protection of due process. A finding of an indicated report and an SCR hearing does intrude on fundamental rights. It can have consequences that are devastating for families, and it has a disparate impact on families that are Black, Hispanic, and Native American who are...
I mean, I gotta say, as a brown-skinned Latina woman on this court, that clearly is something I am concerned about, right? But at the same time, I'm also concerned about those brown and Black babies who get abused by people, and there's no recourse for them, okay? So there's two sides of this racial coin that you're referencing, okay? So it seems to me that here, where there's been a finding at the investigative level that this accusation was true, the fact that the family court later, in an attempt to keep the family together, ACD's a case, doesn't now mean that we should expose other Black and brown children to further abuse. So I fully take very seriously the impact this has on my particular community. But my particular community is not limited by mothers and fathers who are accused of beating their children. My community includes those children and the future children that may be watched by people with these accusations that have been established. So there's a lot to factor in here, but I appreciate the amici briefs that were submitted to this court. We very much have taken them into deep consideration and understand the policy implications that you put forth, and I thank you on behalf of this honorable court.
Thank you, Your Honors.
And counsel, you have rebuttal time.
Thank you. There's no disputing that a teenage child suffered injuries. The dispute is who caused the injuries. And the only connection between the injuries and Shani Jeter, the child's mother, was the statements of that child herself, a troubled teenager with a history of making up stories, who retracted her accusations in writing, and yes, she signed it, in the family court while represented by counsel.
Counsel, but counsel, your arguments all go to the heart of what the ALJ or what the hearing officer found. And in terms of that, I mean, she made credibility findings that are very difficult. You're asking, well, speaking for myself, you're asking me to accept your arguments and tell me, and basically say that I reject the hearing officer's, credibility determinations. I wasn't there. I mean, that's a really tall task to ask me to do, right?
I'm not asking the court to reject the hearing officer's credibility determination. because what we are asking is that the hearing officer be required to make a credibility determination, including the credibility of the child, and based upon all the evidence. And as the court is aware, the administrative law judge would not allow Ms. Jeter to present her daughter's written and signed retraction. And the administrative law judge said,
Wow.
I don't take things from children. When the credibility of the child's statement that the mother was the one who inflicted the injuries was key, and that had Ms. Jeter had a lawyer, that would have been brought out. Equally, she would have brought out the fact that, and it's in the record.
It was brought out, was it not?
What was not?
Everything you just said was part of the record, no?
Your Honor, the question that the court had raised was, how did this signed document get to the family court? And in fact, if Ms. Jeter had a lawyer, the lawyer would have presented the evidence that...
And the judge would have likely made the same ruling because it's based on case law.
Oh, Your Honor, I do hope not. The judge needs to assess the credibility of all the witnesses, the accusers as well as the defenders, and the judge made no credibility findings about the child. The child who had retracted this accusation, the child who had told her own therapist...
How old was this child?
13 years old, Your Honor.
Okay. Was there any attempt to have this child interviewed by the court in camera or anything like that?
Your Honor, that would have been a good idea, except...
Was it proposed by your client's counsel? Because it seems to me
Ms. Jeter didn't have a lawyer. She was pro se. She wanted a lawyer.
Did she offer to have... Look, if the kid really wanted to recant her story and wanted to come to the court and say, you know, this was all a lie, I was just angry at my aunt, they never beat me, I beat myself, as Mr. Lang tried to convince the court that she inflicted these injuries upon herself. Was there anything to stop them from bringing her to court so she could testify?
To the administrative hearing?
Yeah.
Because she was in court. The child was in the family court.
Was she allowed, did anyone ask to let her testify?
Your Honor, I think I would submit that that's why they agreed to an ACD, because ACS's case fell apart. They began to realize that the child had not told the truth about how she sustained the injuries on the afternoon of June 3rd, 2019, when she had no injuries.
So you're going with the story that she did this to herself too?
What?
So you are going with the story that she inflicted these injuries on herself?
Your Honor, I have no idea how she sustained the injuries. I know only that when she left for school in the morning, she had no injuries. That's what her sisters said. That's what her father said. There were no injuries. The school teacher, her own school teacher, said the child never complained about being injured. These are mandated reporters. They saw nothing on the child's body. The injuries appeared on the child's body in the late afternoon after the child had been missing for several hours. Then she came back with injuries.
In the late afternoon?
In the late afternoon. She showed up at
When you say late afternoon, what are you talking about?
We don't know, because that's not in the record, and Ms. Jeter never knew what had happened. She reported her daughter missing to the police. She was frantic. And it wasn't until late in the we don't know exactly when, the child was brought to the police by a teacher at another school.
But counsel, one question.
I'm sorry?
One question. I mean, we're aware, aren't we, that children, just like domestic violence survivors, just like people who are intimidated, often retract their statements, don't they?
Sometimes people who are intimidated retract their statements. Sometimes people who make up stories that are not true retract the stories that are not true.
And a child who's living with an aunt, with her siblings, who's terrified that that family may be torn apart, could be capable of retracting a statement that perhaps would tear that family apart.
Your Honor, that is one reason. First, the child signed a statement while she was represented by counsel in the family court with the retraction.
Counsel, may I
The
interrupt
child-
you for a second? Counsel,
sir.
this is Judge Scarpula. May I interrupt you? When you say she signed a statement, was that the statement that said, my aunt doesn't abuse me, I want to live with her, and I want to go to church?
That's
Those
correct. It's
three
on
things,
page 48
right?
of the.
Yeah, those three things. My
okay.
aunt doesn't abuse me, I really want to live with her, I want to go to church, right? Didn't say, no, I lied about it. It said, my aunt doesn't abuse me, I want to live with her, I want to go to church, right?
Correct.
That's what you're calling the recantation?
That's one of the things, yes. The other thing,
What
another
else?
thing.
Well, that's the thing you keep saying, that it's signed and it's that's, I just want to make sure that that's what we're both talking about. That little piece of paper that says, my aunt doesn't abuse me, I want to live at her house, I want to go to church.
My aunt and uncle have never abused me.
Right.
I was angry, and because of it, I acted irrationally. I never wanted any of this to happen.
I know so many 13-year-olds.
I don't necessarily agree that that's a recantation. I just wanted to make sure that we're on the same page. That's what you're waiving.
Okay.
All right, either way, I think we've got it. We have your papers and your arguments. I thank you. Thank you, one and all.
Thank you.
People versus Daquan King. You may proceed.
Thank you, and may it please the court. Nicholas Raskin from the Legal Aid Society on behalf of Daquan King. This court must vacate Mr. King's conviction and grant his motion to suppress. The police violated Mr. King's Peyton and Miranda rights in order to get him to confess to a crime outside the presence of counsel. The police arrested Mr. King in violation of Peyton when they surrounded his apartment door early in the morning, banged on that door with increasing force over 40 minutes, twisted a locked doorknob, and told Mr. King's family that they would not leave until Mr. King surrendered.
Is there anything illegal about a police officer going to the home of a suspect of a crime and attempting to get their cooperation and talking with them, etc.? Is there anything illegal about that?
Your Honor, there's nothing per se illegal with the police showing up to someone's house.
Okay.
But
Is there any case that says that once a person in this scenario does not open the door immediately, that the police have an absolute duty to leave?
Your Honor, there's nothing but an absolute duty, but here the police were acting unreasonably and in violation of Peyton because they were surrounding the door.
When you say surrounding the door, they're in the hallway of an apartment building. So wherever they're standing, they're going to be surrounding the door. So let's move beyond that, because that really has no teeth. Tell me, did they ever breach the actual threshold of the apartment, pulled him out, threatened anyone inside the house, other than saying, we're not leaving?
Your Honor, the police did not go into the apartment.
Okay, did
but-
they threaten anything other than, we're not leaving?
No, Your Honor, but that itself is a significant threat. They were blocking the only exit to the apartment, and they indicated they were not going to leave until Mr. King surrendered. Mr. King was in the apartment with his whole family. His sister, who's a student, had a test that day. She didn't know if she could leave the apartment.
Counsel, so the defendant left the apartment preceded by his mother, right?
Yes.
His mother went first, so his sister could have gone second, right? And arguably, he could have stayed behind. There was nobody pulling him out.
There was nobody pulling him out, and but the issue is, Your Honor, that the police indicated they were not going to leave until Mr. King left, and that created an environment where the people in that apartment felt unsafe. They didn't feel as if they could leave.
Well, but look, what you feel and what you understand based on communication are two different things, right? So, look, I get it. You have police knocking, banging, whichever way you want to describe it, on your door. That's going to make the people inside the apartment uncomfortable, nervous. I get it. But at no point did the police say no one in the house can leave, did they?
They didn't say that, Your Honor, but
So that if the mother said, well, I have a daughter who has a test, she needs to leave this apartment, I see nothing in this record that these police officers would have interfered with that.
that situation didn't come up, Your Honor, but the
Okay.
fact remains that the police were blocking the only exit. I think it's meaningful that Mr.
Counsel,
King's...
most apartments have only one exit, so I don't get what you're saying.
My point with the police blocking the exit is that they created an environment where the only way the situation was going to end was...
But then I started this questioning by asking you, did they do anything illegal by saying, we're going to stay outside the store until you come and talk to us, right?
Your Honor, my initial response was that there's nothing per se illegal with the police simply showing up, but...
But so you are now saying if a person who is the subject of the attention of the police has a police officer knock on the door and say, I'd like to talk to you, you want us to then rule that if the person does not agree to come out and talk, they have to leave.
Your Honor, what happened here was more than the police is showing up. They were there for 40 minutes until Mr. King came out, and importantly, Your Honor, the police could have gotten an arrest warrant in this case. They knew where Mr. King was.
Yes, they could have. Yes, they could have. I agree with you 100%. They chose not to. The issue is, at the end of the day, again, do you want us to rule that if a subject of interest who the police want to talk to about a crime says, I don't want to talk to you, I'm not coming out, the police have an obligation at that point to leave?
I'm not advocating for a per se rule, Your Honor, but in this case, the police were obligated to leave. They had been there for 40 minutes again. It's clear from the situation that the family inside, Mr. King, Ms. King, felt uncomfortable leaving. Mr. King was effectively forced out of the apartment because the police indicated they wouldn't leave until he surrendered.
Sir, how is this case distinguishable from McBride?
I'm sorry, Your Honor?
How is this case distinguishable from People versus McBride from the Court of Appeals?
I'm not familiar with...
Where the court held that there's nothing illegal about the police going to an apartment and requesting that a defendant voluntarily come out.
Your Honor, this is something more than the police just showing up and asking for someone to leave. This is the police, through a physical show of force on top of...
Counsel, if you look at other cases, Mindley, Garvin, Robinson, the police can't compel a person to exit their home by threatening the defendant. That didn't happen here. By threatening to break the door down. That didn't happen here. Or by ordering the suspect out at gunpoint. That also did not happen here.
Your Honor, I think that there was a threat here, and again, the police were even twisting...
What was the threat? We're not leaving?
Not leaving, twisting the doorknob, indicating when Ms. King tried to call a friend to ask what to do, the police interrupted that conversation and said, the only right answer here is for Mr. King to come out. It's not any one thing that the police did, it's the totality of the circumstances over the course of that 40 minutes that create the threat. And, Your Honors, if I may just say...
No, you'll have time on rebuttal. We're way over our 6 minutes, but you'll have 2 minutes on rebuttal, okay?
Thank you.
Thank you. You may proceed, counsel.
Thank you. Good afternoon, and may it please the court. David Gagne for the people. As stated in our brief, the defendant validly waived his right to appeal, and that waiver forecloses his appellate claim.
Let's deal with the real heart here. Forget the waiver of right to appeal. We've got a patent issue.
Yes.
They had all the information they needed to go get a warrant. Why didn't they do that?
Your Honor, it is whether or not they could have gotten a warrant is entirely irrelevant.
Oh, it's not irrelevant. We
Yes,
know
it is,
why
Your
they
Honor.
didn't do it.
Your Honor, the subjective intent of the police officers is entirely irrelevant. That is a bedrock principle of Fourth Amendment jurisprudence, and that is in People v. Garvin.
Yes, counsel,
2017.
but we both know that the reason why search warrants are not sought is because then you can't question the defendant, right? Under New York law?
Yes, Your Honor.
Okay.
But that has been...
So let's not, look, I understand what the case law says. You heard me on the other side, right? But clearly, these issues would be avoided if where you have clear indication of who you should be arresting, you get an arrest warrant. For God's sake, you had enough here.
Your Honor, it may have been possible for them to have gotten an arrest warrant. It's really not made out in the record whether or not there was a sufficient nexus to this particular apartment. There was certainly probable cause for the arrest of the defendant.
Definitely.
So, but it's irrelevant whether or not they could have gotten a warrant. It's a legitimate police tactic to go up to an apartment, knock on the door, and see if they can speak with the defendant or the suspect.
Was that all they did here, was go to the apartment to see if they could speak to the suspect?
And then once he left, they arrested him. That's true, and that is an entirely legitimate police tactic, and that's been upheld repeatedly by this court and the Court of Appeals. And People v. Dunton decided just 2 years ago by this court, there were 9 to 11 police officers outside the apartment. They went up to the apartment door. They said that they needed to speak with the suspect. And we held that that was not a constructive violation of Payton. There was no breach of the threshold, and so there was no violation of Payton.
You would agree, counsel, that the police could have knocked on the door, said, we want to speak to him. No, he's not coming out. Okay, you leave a couple of cops there, you go get the warrant, you come back.
Your Honor, that may have been an alternative that they could have chosen.
Instead of pounding on the door for 40 minutes.
Your Honor, that
And twisting the knob.
Right, so those statements refer to testimony that were made by the defendant's mother. And those statements were not included, however, in the judge's factual findings. So the court implicitly discredited some of those exact statements that you were referring and that my adversary almost relies entirely upon. So
under Reynoso, there's no Payton violation if the defendant voluntarily exits the apartment. So was this a voluntary act by the defendant here to leave the apartment?
yes, it was entirely a voluntary act. Based on the totality of the circumstances and based on what the police did, his decision to leave the apartment was entirely voluntary.
Yeah, well, it was either leave the apartment or stay here forever. He didn't have counsel has made a very, accurate point. Right?
Again,
so he either stayed in the apartment. I don't know what floor this was on, whether he had the option of climbing down, but he either stays in the apartment or he comes out and gets arrested.
Your Honor, I think that's a somewhat unwarranted assumption. The police were outside for 40 minutes.
And they said they weren't leaving.
Again, that is another statement that was not included in the judge's factual findings. So there's no indication. The only fair reading of the court's factual findings were that those statements were not credited. If he had decided to credit those statements, he would have included them in the factual findings. They would have been relevant. And I would just add that in this case, the police were outside for 40 minutes. In Dunton, the police were outside the apartment for an hour and 45 minutes. It's not like 40 minutes is going to magically render the defendant's decision to leave the apartment involuntary.
That's the strongest argument you've made.
Thank you.
Anything else?
Unless there are any further questions, I just ask that you affirm.
Thank you. Counsel, you have 2 minutes.
Thank you, Your Honor. I just want to start with a couple of quick rebuttal points. Respondent mentioned that the fact that the police could have gotten a warrant is irrelevant, but I think the fact that the police could have gotten a warrant and then the right to counsel would have attached is illuminating in this situation. I think that the police staying in front of the apartment door saying that they wouldn't leave until Mr. King came out was an attempt to subvert that process of having to go get a warrant instead. And I think going to respondent's second additional point that the court implicitly discredited Ms. King's statements. The trial court never said anything about discrediting Ms. King's statements. I think that if the court actually did not credit one of the 3 witnesses who testified at the hearing, the court would have mentioned something about it. The court would have said that they didn't credit Ms. King's testimony. They would have probably given a reason. In this case, the court not only did not mention a reason why they would not credit Ms. King's testimony, the court actually credited her testimony and said that her testimony was consistent with the court's factual findings. Our contention is that given that the trial court made those findings of facts, the court necessarily arrived at the wrong conclusion.
No, I think the court was saying, I believe what she's saying, but those facts as a matter of law don't constitute a violation.
Yes, Your Honor, and that's where we disagree. We think that that is a patent violation. And I would just, before my time runs out, like to very quickly touch on the excessive sentencing issue.
Okay.
Mr. King was 23 years old at the time of the offense. He'll be 40 years old at his maximum expiration date. That's his entire young adulthood, effectively. And the record, although the case didn't go to trial, the record indicates that he might have acted in self-defense during a coercive sexual encounter.
Counsel, I'm sorry. He admitted having an arrangement for sexual favors with this victim. And for God's sake, there were 2 people in the apartment while he strangled this man to death. He took a life. He
Yes.
took a life. Okay? So it's very hard for the members of this court to have to consider such a long period of time for such a young man. But on the opposite side of that, there have to be consequences for the actions that take a life that is forever, right?
Yes, Your Honor, I completely agree. And if I could just quickly say that in any instance of manslaughter where someone pleads guilty, that's a very serious offense that involves the taking of a life. And the legislature enacting penalties for manslaughter made the minimum 5 years. And
Counsel, does the record indicate anywhere that the defendant called out for help?
There's no indication that he called out for help during the encounter, but there's...
You would agree that there were other people in the apartment who could have provided help, right?
Potentially. The record's not clear as to whether Mr. King knew there were other people in the apartment at the time the encounter was happening, but the record does indicate that when he left, he did see the decedent's neighbors, and he said that the decedent had tried to rape him. And again, this is a very serious offense, just like any instance of manslaughter is, but Mr. King's sentence on the higher end of the possible penalties for manslaughter, given his age, is excessive, and that's why we make that argument.
Thank you. We will consider them seriously.
Thank you. I appreciate it, Your Honors.
Anonymous versus anonymous. Oh, did I skip one? I'm sorry. Sorry, I called. Forgive me. You're next. Gerzak versus Goldfarb. My apologies to both sides. Who's up first? Okay. You may proceed.
Good afternoon, Your Honors. My name is Michael Munoz. I represent the appellant Stephen Goldfarb. May it please the court. This case is premised entirely on an alleged conversation that occurred in 1995 or 1996, the terms of which have been disproven through discovery. The discussion between the plaintiff, Mr. Gerzak, and my client, Mr. Goldfarb, as Mr. Gerzak alleges, had 2 components. One, Mr. Gerzak says, and he says this over and over and over and over again in his pleadings, in his deposition testimony, in affidavits, Mr. Gerzak says very clearly and specifically that the 2 men agreed that Mr. Gerzak would receive 1/3 of the firm's profits going forward as a partner.
Well, before you even get there, you have to have a partnership, right?
Correct, Your
right?
Honor.
So before we even get to the percentages, why do you think Supreme Court erred in finding there's a factual issue in terms of whether or not there was a partnership?
The question, Your Honor, is whether the parties came to a meeting of the minds, whether there was an agreement. And when one party says, this agreement had two terms, I was going to get a third of the profits and I was going to contribute.
Okay, all right, let's break it down back to the bar review courses. We know from partnership law is like, to be a partnership, you got to share losses and profits, right? So we have a situation here is that you made an argument about losses, that Mr. Gerzac did not share in the losses.
That's correct, Your Honor. Mr. Gerzac has been completely unable to point to a single cost or loss of the firm that he himself.
Well, not exactly. I thought the record indicated that whatever he got paid in terms of whatever distributions, that was net of losses or that was net of any expenses.
Your Honor, I submit that that's just speculation. Mr. Gerzac himself, when asked to identify his costs.
Well, that can't be speculation because the accountant and Mr. Goldfarb would know the answer to that, right?
Your Honor,
they're saying, no, that wasn't the case. So then you have now, as the Supreme Court pointed out, hey, there's a factual issue here. One says no, one says yes.
Respectfully, with all due respect to the lower court, the lower court in that
Don't worry, Judge Kohler knows what he's doing. It's okay. You don't have to respect him, right?
He's
been around the block a lot, as he
absolutely.
said in his decision.
Absolutely. And, he was engaging in a way that he was trying to articulate, I think, a way in which Mr. Gerzac could have participated in the losses. But Mr. Gerzac himself, when asked at his deposition, in his pleadings, in other affidavits, he doesn't say that. That's just, that is a very charitable way to rearrange the facts such that Mr. Gerzac.
What about the line of credit?
I'm sorry.
What about the line of credit that he had?
All we know is that Mr. Gerzac signed for it. There's no indication in the record that he ever actually, came out of his pocket at all.
It doesn't matter whether he came out of his pocket. He was exposed.
I agree, Your Honor, that on that one particular instance, he has a point that he may have been exposed.
He also alleged that there were times when he didn't get paid at all because the outflow of money wasn't there. Sounds to me like he was taking a loss.
Well, Your Honor, there was no evidence that the parties agreed, okay, this is how I'm going to take the loss. This is how I'm going to fund the loss.
Counsel, I agree with you. It wasn't reduced to writing, okay? But we have a quintessential, one party is saying this is what the agreement was, and we have another party saying, no, that's not what the agreement was.
Respectfully, Your Honor, it goes well beyond
Counsel,
that.
do me a favor. You can dispense with the respectfully. We all know what that means, okay?
Your Honor, in that case, it goes well beyond that. Here, when Mr. Gerzac is asked to identify the terms of this agreement, he only identifies two terms. Both of those terms are disproven by documents. He says, I was entitled to a third. One of the terms is I was entitled to a third of the profits. He cannot dispute that he never, ever, in a single year, received a third of the profits.
I thought there was 1 year where arguably he did.
I believe there was a year
2012?
There was a year where he got
recall
29 or 30%. But that is 1 year, and it's certainly not a third. And there were other years that clearly deviated from that.
Counsel, this is Judge Scarpula. Didn't they file partnership tax returns?
They did file partnership tax returns.
So
Now,
if there's no partnership, right, then that would sort of lend credence to the idea that there is a partnership, right?
Your Honor,
and wasn't he listed as a partner on the firm letterhead?
Your Honor, we all know that there are partners who are not.
I'm just right, but you're saying to us, as a matter of law, hold that there was no partnership, even though the firm filed partnership tax returns, and two, even though the partnership held itself out, or the firm held itself out as a partnership. And I'm wondering, and he says the reason why I didn't get my third is not because I wasn't entitled to it, but because the defendant ripped off and took all these personal expenses, and therefore I didn't get my third. And that's all disputed, correct?
Let me address both of those points, Your Honor. The question here is not whether there was a partnership, but whether the parties agreed to function in the way that.
So you agree that there, wait, okay, so let me go back, please, and ask you, so you agree there was a partnership?
There was no partnership entitling as Mr. Gerzak himself wrote it, his compensation was determined by Mr. Goldfarb at Mr. Goldfarb's discretion. He's suing for money damages here. He's not suing for a declaration that there was a partnership. He's suing for money damage based on what he says is a very clear agreement.
I don't understand you. I don't understand you. Are you saying that there was a fraud that was perpetrated then? There was a website that said that the plaintiff was a managing partner. There were tax returns for a partnership. There were K-1s instead of W-2s given out, right, or issued. So both the plaintiff and the defendant were described as limited partners. So are you saying that that was a fraud? That was all false?
There is no dispute that Mr. Gerzak held the title partner. There is also no dispute that he was never entitled to 1/3 of the firm's profits.
All right, well, that is disputed, and you'll have time on rebuttal.
Thank you.
Good afternoon. Christopher Scozen, Furman, Kornfeld, and Brennan for Appellant Harvey Migden. May it please the court. There may have been a partnership agreement, but there was no meeting of the minds as to what that agreement was. And Mr. Gerzak basically acknowledged the fact that his compensation was at the discretion of Mr. Goldfarb in writing. That understanding could basically rebuts any allegations of aiding and abetting, breach of fiduciary duty, or breach of fiduciary duty against Mr. Migden. Mr. Migden was...
Well, with Mr. Migden, he has different obligations as a professional in this field, correct?
As a tax preparation accountant, yes.
Well, he didn't just do tax preparation. Come on.
That's what Mr. Migden
I know that's
did
what
to
he
the firm.
says.
Yes, well, Mr. Migden, prepared the taxes for the firm. He also, this is a small firm. There's two partners or two attorneys.
Well, you got it right the first time.
And so as a tax accountant for the firm, he prepared the taxes of the two attorneys individually.
Counsel, do you disagree that personal expenses were deducted as case preparation costs in the amount of over $4 million?
There's no evidence that Mr. Migden deducted personal expenses.
There's plenty of evidence of that. Some of the categories are just obvious personal expenses and not at all case preparation. And as a professional, he has an obligation to not rubber stamp false designations and classifications of expenses. This is, after all, going to the IRS.
That's true, Your Honor, that he doesn't have a duty to rubber stamp anything, but it's only speculation as to what was a personal expense, as to whether or not Mr. Migden deducted any personal expenses. Mr. Goldfarb worked from home, and he had expenses, for his personal practice. And Mr. Goldfarb basically instructed Mr. Migden as to what was deductible and what wasn't.
But the obligation of an accountant is to advise their client. No, that's a red flag. That's not a proper expense for business.
Well, Mr. Migden testified that he did do that if there was something that was
But yet
an
there
issue.
is like a slew of items in the record, and I'm looking in my to give you the exact examples of some of the items that were deducted that clearly are not case preparation items. Personal credit cards, his residence.
These were not, there's no evidence that these are deducted, Your Honor. Those are from the report of plaintiff's expert Andrew Ross, and he was instructed by plaintiff's counsel to assume that those were personal
Oh,
charges.
counsel, you're agreeing that there are many, many, many issues of fact here, right?
I'm sorry, Your Honor?
You're agreeing that there's many, many, many issues of fact that can't be decided on paper.
I don't agree that there are issues of fact, Your Honor, because
There was payment for a relative as an employee of the firm who never worked at the firm. Sounds to me like that's a issue of fact. I want to know who they are and what they did at the firm, that money paying them should be appropriately reduced from the profits of the firm.
Mr. Goldfarb would have explained to Mr. Migden what the purpose of that was, and as the tax preparation professional, he was entitled to rely on good faith without verification.
But we don't have to, is our point. So there is a allegation that this person was paid as an employee, but was never, ever, ever an employee at the firm. That sounds like a quintessential issue of fact.
That's basically based on speculation from Mr. Ross, the expert for the plaintiff. But you have to take a step.
But the plaintiff said these people didn't work at the firm. He would know since he was the managing partner who dealt with the day-to-day operations, right?
There was two attorneys at the firm, and he was the attorney who was in the office. Well, Mr. Goldfarb, who was the trial attorney, worked outside of the office predominantly. But the understanding at the firm was that Mr. Gerzac's compensation was at the discretion of Mr. Goldfarb. So to the extent that there's any issue with what was deductible and what was not deductible, Mr. Migden would have had the same understanding as Mr. Gerzac that his compensation was discretionary. So
yeah, but we're mixing apples and oranges now because I'm talking about.
I mean, that's
counsel. I'm still talking.
I'm sorry, Your Honor.
We're mixing apples and oranges because now you're talking about his compensation and whether they agreed on a third, and I'm talking about the expenses that Mr. Goldfarb wrote off, had the firm pay, and thereby reduced potential available compensation to the partners. But you will have time. You're out of time. Thank you.
Thank you, Your Honor.
And counsel, we will hear from you now.
Good afternoon, Your Honors. Josh Wartzel from Schlomstone and Dolan for the respondent.
Oh, hang on a second. Unless I heard wrong, I think the appellant said that there is a partnership agreement, because I thought that was the first line of questioning that Supreme Court had, was whether or not there was a partnership, right? But it seems like he's saying that there is a partnership, but there was never an agreement as to your client getting a third.
Your Honor,
did I hear that wrong?
I think they've shifted a few times. They've started out saying
I thought so.
Right. They started out by saying Mr. Gerzac was just an employee, de facto employee.
Right.
And then Mr. Goldfarb admitted, well, he was an employee, but he was entitled to get a percentage of what I drew from the firm. And then Mr. Goldfarb.
It's called non-equity partner.
That's what they've said more recently. So I'm not, Your Honor is right to be confused because they have shifted. I think taking their argument, the best spin on their argument is that, sure, there might have been a partnership, but there was no agreement for Mr. Gerzac to receive a specific amount of.
Well, we know in the partnership law, you don't have to have, it doesn't have to be in writing. This arrangement's based on this record, unless I'm reading the wrong record, there's no writing here, right?
That's correct.
This is all based on an oral, sharing profits and losses, right? Back to the bar review course, right? That's how you create a partnership. Right?
That's correct.
The question is only, are you entitled to a third of the profits, right?
That's correct. If it were in writing, we probably wouldn't be here. But because it's not in writing, that's why we're here. And
then going to the accountant's argument about how your expert was told to pick out, or at least cherry pick expenses, did they have an expert coming back saying, no, your expert's wrong?
They did not, Your Honor.
Yeah,
And-
okay,
and
so, okay.
That's correct. And specifically what was done was Mr. Gerzak identified about 2,000 charges on the firm American Express,
Yeah, one of them was going to Disney World.
Disney World, Oceanic Cruises, trips to Europe,
pretty nice.
wine, New Jersey Devils. Mr. Goldfarb liked to go to Devils.
Well, maybe he's looking for clients. He could be, that could be client development, right?
Mr. Gerzak says that that wasn't something they did. I mean, this was a personal injury firm. They didn't necessarily develop
There's
clients.
a lot of slip and falls in Disney World, probably.
Fair enough. But we served a notice to admit on Mr. Goldfarb and asked him of these 2,000 expenses, which are personal and which are not. And he admitted that a handful were personal. And he said, I don't know about the other 1,900. So it's not that the expert picked out only certain charges. There was a basis for doing that. And as Your Honor pointed out, the defendants had an opportunity to come in and say, no, these were not personal. And even when given that express opportunity in the notice to admit, Mr. Goldfarb just said, I don't know, I can't remember.
Sir, what about your friend's argument that Mr. Migden was permitted to rely on whatever representations were made to him by the other partner regarding the nature of those expenses?
So that argument is fine as far as it goes, but Mr. Migden testified that he didn't rely on Mr. Goldfarb. He testified that he made the determinations about what to deduct himself. And when I asked him at his deposition, well, what documents did you rely on to make those decisions? He said, I had none. And when I said, what information did you rely on? He said, I had none. And as this court has also pointed out in questioning, it is the obligation of an accountant, and this goes to the negligence claim, not just to rubber stamp. If I go to my accountant and I say, I just spent $25,000 in Disney World, that's all business development.
Counsel, this is Judge Scarpula. I want to ask you about the fraud claim. What are you claiming was fraudulent?
Mr. Goldfarb made representations to Mr. Gerzac that he was receiving the amount of, that he was receiving 1/3 of the profits. He made representations to the effect of, you're ahead of me, you've actually taken more than your share, and so on.
Well, wait a second, but didn't your client sign the tax returns every year?
He did not. Mr. Goldfarb signed the tax returns.
But did your clients get the tax returns every year?
He did not. He got his K-1. That was the only thing he
got
received.
he got his K-1s, right?
Correct.
So the K-1s would have shown him that, correct?
Well, the K-1s only show the amount of income that's allocated
No,
to
they
him.
would have showed him whether or not that representation was true,
Like,
correct?
It would have, but
Yes, okay, so he got the K-1s, that's the you're saying there was a misrepresentation, but he got the document that would have disproven it. So where is the justifiable reliance?
Your Honor, Mr. Gerzac testified that he didn't understand the K-1s. He didn't understand the percentages.
He's a lawyer, right? He's a lawyer. We hold people who can't speak English to documents they sign. He's a lawyer.
Your Honor, just if I could finish the question, Mr. Goldfarb would repeatedly tell Mr. Gerzac, you're ahead of me, you've taken more.
Again, I agree with you. That's what the allegation is, but the question is whether that's a justifiable reliance on that when he has the document that would conclusively or that would disprove that misrepresentation.
And he had the ability to check the records. According to the record, he always had the capacity to check for himself the records. So if he accepted the statements of Mr. Goldfarb without availing himself of his own due diligence, how can we find that there was fraud since the element of justifiable reliance seems to be at issue here?
So let me just answer that. Because these two men were in a fiduciary relationship, there was not an obligation of Mr. Gerzac to go out and undertake an independent inquiry. That would be the case if there weren't a fiduciary relationship.
That is just not really even counsel. That's not the law. If you and I are shareholders and you allege that I have a fiduciary duty and you also allege misrepresentation, there's no law that says that you have no obligation to check what you're given to find out whether or not there's justifiable reliance. There's plenty of law out there to the other way.
Your Honor, if I could just refer the court to Frame against Maynard, First Department, 2011. Court held that a fiduciary is entitled to rely on a co-fiduciary's representations and his complete and undivided loyalty without performing independent inquiries.
All right.
No, we're not talking about independent inquiry here. We're talking about they both have the same information. That's a different situation. That rule is for a different situation. But okay, thank you.
Thank you. Your Honor. All right, and you have 2 minutes on rebuttal.
Thank you, Your Honor. I think, to me, the question here is not whether or not there was some partnership agreement. It's whether the plaintiff is going to succeed on his claims on the specific agreement that he's alleging. If the specific agreement that he's alleging has been disproven.
You know what, the specific agreement, you keep using that word. This is an oral agreement. There's no writing here, right? It's
Yes.
what he says versus he said. That's it. So when you say specific agreement, don't let me go down that rabbit hole. There's no agreement here.
This is not a case of he said, she said. The agreement
he said.
that he said. The agreement that Mr. Gerzak alleges is completely belied by his own writing afterwards when he says, not I'm entitled to a third, but I make money at your discretion, Stephen, based on your generosity.
But you know what? That to me doesn't automatically knock it out of the park, because it could be that Goldfarb made this agreement to a third, and then once it came time to pay, he decided, you know, this ain't in writing. I'm not going to give him a third. I'm going to give him what I want. And that Gerzac decided, let me keep at it. I like what I'm doing here. I think I can make this work, and get him to reduce this to writing based on what we've decided. So I don't know. All I know is I have one person saying one thing, one person saying another, and I have some really questionable accounting.
If I may say one thing on the fraud claim, in addition to the points that your honors have made, there was equal access to information. The information was all in the office where Mr. Gerzak worked. Mr. Gerzak testified that in 2007 or 2008, he confronted Mr. Goldfarb. He confronted Mr. Goldfarb and said, I see you've been taking money out of the firm. I am alarmed. You are dissipating money at an alarming rate. And that's in 2007, 2008 by his own admission. That just further shows that he failed, despite having some indication in his mind that something had gone wrong, he failed to follow up and examine any of the information or any of the that's available to him, and it's his reasonable reliance. Therefore, is completely unreasonable.
Thank you.
Thank you, Your Honors.
Counsel.
Thank you, Your Honors. I just wanted to add that when it comes to the references to Disney vacations and things like that, of course, Mr. Migden did say that, you know, he made decisions. As an accountant, he has a certain amount of discretion when he's going through the tax records and to decide if something's deductible or not. And of course, if something is labeled Disney vacation, then he's going to make the decision that that's not a deductible business expense. Again, plaintiff's expert.
Yeah, but did you come up? You know, that's what I wanted to ask you. Did you come up with an expert, or did you present the proffer an expert to say their experts were totally off base with all these expenses?
Yes, we did, Your Honor.
You did? He just said you didn't have an expert.
No, he's talking about Migden.
That was not me.
Oh.
Yes, we have an expert, Your Honor, and our expert
is the client itself.
Categorically that there was no.
Well, then during the deposition, he asked them, "Where's the backup to it?" And did your client answer properly, or according to counsel's statement that your client says, "I don't have the backup"?
Well, the issue is, Your Honor, that you know, his expert basically was directed by plaintiff's counsel to assume that these charges were all deducted, that these personal charges were deducted.
On what basis do you have to make that statement?
It's written in the report of...
That his client told him what to say?
Yes, Your Honor. It's in the record at page 2565 and also 2566.
That I'm hiring you to do this expert opinion, and this is what you have to say.
Well, it's the report of Andrew Ross, and he states that he was asked by plaintiff's counsel to make an assumption that all of the charges were by or for the benefit of Stephen Goldfarb.
Okay. All right. Thank you. We're out of time.
Thank you, Your
You
Honor.
have your record and your briefs. Anonymous versus anonymous. You may proceed.
Thank you. Good afternoon, Your Honors. May it please the Court. My name is Alan Mantell. I represent the appellant. This appeal is from a decision and order of the lower court dated June 2021, which drastically reduced the level of the prenuptial agreement standard, quote, ordinary and necessary living expenses during the pendency of this action. And it's an appeal from an order that woefully inadequately awarded inadequate counsel fees to my firm and to our forensic accountants. Despite the lower court's order, the lower court and the record have clear indications of what the standard was for years established by the plaintiff, the payor, a man who made either $59 million a year in 2015 or $19 million a year in the year in which this case was before the court, $19 million a year, forgetting about the fact that his net worth is probably in excess of $500 million. That standard that was paid by the plaintiff for years after the date of commencement, as indicated in the record, was $350,000 a month to my client directly by check and or American Express, all expenses for 3 homes, private airfare, annual vacations of 4 and 5 times a year, household staff of 5, and all school-related expenses. The totality of what the plaintiff admitted and what Ms. Krause said was his obligation in an affidavit in June of 2019 exceeded $4 million a year.
So, counsel,
Nevertheless,
you would agree that the
I'm sorry?
divorce, you would agree that the divorce of these 2 persons was an operative event pursuant to the prenuptial agreement, right?
So an operative event occurred upon starting the action, and the agreement
So you're
defined
saying that the
these
divorce...
payments-
Counsel, please allow the bench to finish their statements.
Apologize.
Thank you. So you're saying that the divorce was not an operative event? I read here the Article 2 of the prenup defined an operative event as the date that occurs 90 days after either party commences an action against the other for divorce.
Yes, that's true. And the prenuptial agreement says, from the date of the operative event until the end of the hiatus period, what was required to be paid was ordinary and necessary living expenses based upon past experience during the pendency of the action.
But there has been an issue of fact with regard to what the usual and ordinary expenses were, right?
That is true, but what is not in dispute is what the plaintiff paid and said was usual and ordinary. He voluntarily paid for 1.5 years.
Yes, but the fact that he voluntarily paid does not mean, pursuant to this agreement, that he has to continue
True.
to make payments that he voluntarily made that were above and beyond what the prenuptial provided. Am I correct?
No, because the prenuptial provided ordinary and necessary.
Okay, so then we go back to that there is an issue of fact about that, because the respondent husband here says that in the years leading up to the operative event, your client ratcheted up her spending exponentially.
Well, if there is that allegation,
There is that allegation.
there is that allegation, but the fact of the matter is that the plaintiff approved all of those payments, made all those payments, and their accountant, who got the bills every month, paid them regularly.
Yes,
So
and
that-
counsel, I was on the last appeal, and part of that record reflected that the accountant sat down with them and said, you're spending more than you're bringing in.
Well, the plaintiff did not go to court and say, I need relief, or I want to establish a level. He continued to pay it, and he only...
They were still married. Right?
The operative event occurred in December of 2017. He continued to pay it in 18. He continued to pay it in 19.
And then he said he was done.
And he continued to pay it.
Counsel, under the terms of the prenuptial agreement, the hiatus, if we talk about the hiatus period, which we could talk about forever, he had the option to stop. And he did.
So let me address the hiatus period if I can, Your Honor.
All right, why don't you do that in rebuttal, because we're out of time on your direct, okay?
Good afternoon, Your Honors. My name is Caroline Kraus. I represent the plaintiff respondent. May it please the court.
Counsel, can you lower the...
Yes, the masks do make everything a little bit more burdensome, but yes. So we're here today. Appellant's argument boils down to respondent's high income requires a blank check. That's sort of how I see it. Ordinary and necessary expenses consistent with past practice. In 2015, the record reflects, and Justice Cooper found this as a matter of fact in his decision, the appellant spent $144,000 on her American Express in 2015. That increased exponentially as each
Counsel,
year.
just for the record, that would be for the year or for the month?
No, for the year.
Thank you.
For the year. In 4 years, inflation cannot account for an increase in spending to, in 2018, she purchased a $1.2 million diamond for herself by siphoning off monies from the household account. The household account is an account that was under her control. All of these statements were sent to her assistant at her assistant's home in Virginia. Mr. De Niro's accountants never got those bills. We repeatedly asked, please provide us with the documentation as to what you're doing with the money that's being transferred. In her motion, in support of her motion, she submits a net worth statement that utterly fails to prove her claim. She has generalized statements about groupings of round numbers, things that she claimed that she was paying for Mr. De Niro's homes in Gardner and in Montauk.
Counsel, is there a reason why this was filed as anonymous versus anonymous, or are you forgetting?
No, I'm sorry, Judge. Unfortunately, I'll be more careful. I apologize. Now I've lost my train of thought. I'm sorry. The fact is the net worth statement. While she was in possession of all of the credit card statements and the bank statements that showed how she dispersed these funds, she submitted a net worth statement. Her first one had no budget. It was completely blank. The second one wasn't much better. She had round numbers that were grouped with brackets, and she said, well, I spent $400,000 a year on...
Can we focus on the hiatus period, because that's going to be discussed?
Sure, yes. So what we're talking about here in this appeal is the brief period of time that was supposed to be between the time that the operative event occurred and 9 months later when the hiatus period ended. The hiatus period could have been extended by agreement of the parties, and Mr. De Niro did not take action to end the hiatus period.
No names.
I'm sorry. I'm so sorry. I'm so sorry. It's not intentional. When Ms. Hightower, I'm sorry.
Okay.
I'm sorry. When the appellant made her motion, we cross-moved for a declaration that the hiatus period was over. The support that we're speaking about, this period of time, is during the time after the hiatus period was over and the time that the appellant must leave the residence. This was supposed to be a very short period of time. We've had appeals on the meaning of the prenup. We've had motions for re-argument. We've had motions for a stay to this court. We've had motions to a stay to the Court of Appeals. We've had more motion practice in the court below. What was supposed to be an agreement that set forth a methodology for how we were going to end the marriage. The marital residence was to be sold.
Your
new apartment.
adversary says that because a certain standard of living was maintained beyond the hiatus period, that is the standard by which we must measure spousal support. What do you say to that?
Well, the prenuptial agreement doesn't say that, and you're correct, Your Honors, whoever brought it up, that he did this on a voluntary basis. And as the pandemic ensued, he not only realized that he had to refocus what he was spending his money on, but at the same time, we received documents that were subpoenaed by my office, which revealed what she was spending her money on. And it was nothing that was ordinary, and it was nothing that was necessary. She purchased a diamond. She spent $1.2 million in 1 year at Dolce & Gabbana, at Stella McCartney, at Burberry, Manolo Blahnik.
The American Express card?
Excuse me, Your Honor?
You're referring to the American Express
The American Express card. She also had another credit card with Chase that we did not have access to until we received the subpoena documents, in addition to the Chase bank statements. And then she also had a credit card that she uses for the business that the parties own, that she operates, that we had no access to until we subpoenaed the documents.
Okay, thank you so much. You have 2 minutes.
2 points, hiatus period, legal fees, but there's no doubt that all of these bills were paid by the appellant and the accountant throughout on a monthly basis. We're not saying that the $1 million diamond ring was the standard. What we're saying is that the standard that was set by the plaintiff, $350,000 a month plus the expenses, is the standard that he admitted to. And there's no—
Counsel, this is Judge Scarpula. Is
Yes.
there any expense that you're saying for the child or the home or for her that isn't being met?
Yes.
Any ordinary expense?
Absolutely.
Can she feed ourselves? Can the necessary and ordinary expenses, are any not being met?
Well, so this family had 3 multi-million-dollar homes. He prevented her from using the Montauk Beach house, a mansion, 100-acre plus estate upstate.
And
She
you're calling that a necessary and ordinary expense?
For this family, no doubt. He acknowledged it. They traveled private planes with staff of 5 times a year. The record—
Then they got divorced.
They
Then
didn't get
they got divorced.
They're not divorced yet. Let me just address the hiatus period. Again, this is it. During that 9 months, the agreement said that a designated accountant was meant to look at 14 years of their expenses to determine what is separate and what is marital. They said it was moot. They refused to give any of that information. Judge Cooper, in his February decision, said they have to give that information. The determination of what is marital is for the designated accountant. To this day, not one piece of paper has been delivered to the designated accountant. So that hiatus period of 9 months was intended to define what their economic rights were, and during that 9 months, ordinary and necessary expenses for this family were to be paid. The fact that he has not complied with the
You're saying, wait a minute, you're saying that notwithstanding the terms of the prenuptial agreement, that what determines the usual and ordinary expenses is limited to the 9-month hiatus period?
No,
That's your argument?
No, they are saying that We're saying that the hiatus period was absolutely extended because of the non-compliance with the terms of the prenuptial agreement.
All right, thank you.
One more.
No, we are done. Thank you.
Thank you.
Bumble Trading versus L&L New York 5, NY 5. You may proceed.
Thank you. Good afternoon, Your Honors, and may it please the Court. Alexandra Sobel from Fox Rothschild on behalf of Appellant L&L New York 5. Your Honors, we believe the lower court's decision granting respondent summary judgment motion should be reversed here. The case law makes clear that in a situation such as this, where a court finds that a contractual provision is ambiguous, it must rely...
What's ambiguous?
Well, the lower court held that the provision deeming that the landlord had 30 days to either approve or deny the sublease, and in this case, the landlord requested additional information on day 30. So that to the court was ambiguous.
According to the lease, a tenant who wanted to sublease their space had to provide the landlord with certain documentation, including the financials of the specific subtenant, and that wasn't done here, right?
That is correct, Your Honor, and there was a reason for that that was outside of the appellant's control, and that is that appellant and respondent had a non-disclosure agreement that prohibited appellant from providing respondent's financials to the landlord unless the landlord executed a non-disclosure. The landlord refused. It unreasonably decided that it was not going to do so. And so if appellant did provide those financials, it would have been in breach of its non-disclosure agreement with respondent. Instead, what my client did was it said, okay, well, we obviously have to do something. We're going to force the landlord's hand, file in the bankruptcy court, and have the court hopefully allow the sublease to be assumed by the landlord. And in that case, again, really what we're talking about here is
that your client expected that this sublease tenant should wait indefinitely for you to work this out.
Well, Your Honor, I would just...
It's really what you're saying, that they had an obligation somehow to wait.
Respondent...
Counsel, this sublease tenant wanted to do a hard opening on a date certain, right?
That's correct.
And they communicated that to your clients.
Had respondent truly wanted to get in by a date certain, then it could have inserted, it was represented by sophisticated counsel during the lease and sublease negotiations. It could have put a specific provision, a time is of the essence provision, a sunset clause, that essentially said that if the landlord does not provide approval by X date, then they can terminate. However, under the sublease, they were only permitted to terminate if and only if the landlord rejected the sublease, and that just did not occur here.
But that
Go ahead. Go ahead.
But that wouldn't be necessary if the party's understanding of Article 17D of the main lease was that the landlord had to make a decision within that 30-day period, right?
That is correct. And I will point out that if the landlord, as was the case here, failed to make an affirmative approval or denial, then the sublease would be deemed approved. However, my client realized that under the sublease agreement, it needed to have written approval, which is what it continued to go after in the months thereafter. I would just also prove...
So again, so it was your client's position that this subtenant then had to wait until you could do that.
It's my client's position that if they had to get in by a certain date, then there should have been something in the lease, and the lower court improperly read into the lease its own time is of the essence provision and decided what it deemed to be unreasonable under the circumstances, a job that we submit should have been decided by a finder of fact.
Okay.
If I could just point out additionally that the record demonstrates that appellant, both parties clearly did not view the landlord's request for additional information as a denial, as they both were in contact, and the appellant continued to seek the landlord's written approval, going so far, as I mentioned before, to filing this bankruptcy petition, which Respondents' Counsel was fully well aware of. Counsel for Appellant submitted an affirmation.
I mean, you say they were, go ahead.
Judge Scarpula, I'm sorry, this is Judge Scarpula. How do you explain the letter that says, if you think that both parties were still going for it, how do you explain the subtenant's letter saying, we're done, we're not doing this anymore, the lease is over? That letter literally goes against what you just said about how both parties thought this was still going on.
Well, I will point out that that letter didn't come for weeks and weeks after that initial response from the landlord.
Absolutely. Let me ask you a second question. Did you ever tell that during that 30-day period, did you ask the plaintiff here for permission to give its financials?
Yes, there were conversations. The record reflects that there were conversations between counsel where this was brought up, and Respondent did not agree to waive that requirement. And I will point out that.
So then, did you say that to the landlord? So when you answered this complaint, did you say that you were excused from performance under the lease because of something that was out of your control?
Well, we don't view that we were excused from performance. In fact, we continue to try and perform. We continue to try and seek that written approval thereafter.
Wait, did you just not say that you couldn't perform, you couldn't do your part because you couldn't get the landlord to sign the non-disclosure?
We couldn't do it by that day 30, but I'll note that the landlord didn't outright reject our request for this subtenant. The landlord requested additional information and reserved its decision. And so that to us meant we still have time. It's deemed an approval. Our reading of the lease is that it's deemed an approval because it was not an affirmative denial. And we know that we needed to get that written approval, which is why we continue to go after it.
Thank you.
So then why'd you file bankruptcy?
The landlord would...
If you thought you were going to get the approval, why'd you file bankruptcy?
The landlord was, in our view, unreasonably withholding the consent, and so we had to...
So you knew the landlord was withholding consent. So that's different from what you just said, right? Which was, we thought the landlord, we'd get the documents, we were all still negotiating. But what you did doesn't bear that out. Do you see what I'm saying?
Respectfully, I disagree, Your Honor. I would say that we had...
Okay.
All right, thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court. Farah Tabatabai from Hughes, Hubbard & Reed for a plaintiff, Appellate, Bumble Trading, Inc. The relevant question here that the Supreme Court decided was whether the parties intended that the proposed sublease would go into effect shortly after the 30-day deadline for the landlord to approve or disapprove of the sublease, or whether, as L&L contends, that the parties intended that there would be no deadline for L&L to obtain the landlord's approval, and that the proposed sublease could languish for 6 months or 9 months or any amount of time on L&L's unilateral timeframe or the landlord's unilateral timeframe. And there's simply no evidence in this record, which is undisputed, that supports that argument. All of the extrinsic evidence goes the other way.
How do you address your adversary's argument that as a sophisticated party to this sublease contract, that you did not include a time is of the essence clause with respect to when that lease needed to start from the perspective of your client?
Yes, Your Honor. Well, the time is of the essence clause was not necessary because there was an express incorporation into the terms of the proposed sublease, Article 17D of the lease. And Article 17D of the lease could not have been clearer, that the landlord has 30 days to approve or disapprove. There was no third option. So the parties understood, and there's evidence in the record that they communicated about this 30-day deadline. We will have an answer. Landlord is required to respond, L&L said, within 30 days, so we will know by then. And every party understood that that was going to be the time frame. So there was no reason.
I'm sorry.
Go ahead, Judge Scarpula.
I just want to ask, what do you say to your adversary's response that you knew that they were prevented from performing because you refused to waive the non-disclosure agreement?
That's just not true, Your Honor. The notion that there was a request made by L&L to Bumble for us to waive the requirement is not true, and it's not reflected anywhere in the record. We were essentially in a black box as to what was going on between L&L and the landlord. What they
So you're saying that at no point were you asked to waive the non-disclosure agreement in order to move this forward?
That's correct. There's an email in the record where L&L tells us the landlord is refusing to sign the NDA. We're working on it, essentially. And we let them work on it. And as far as we knew, I think the record reflects you following up every day, every couple of days to find out what the status of the negotiations with the landlord and L&L were. And then the next thing we heard after that was not, can you waive the requirement? Could we do something else with the NDA? They're requesting this change or that change. In fact, there's emails from L&L to the landlord in the record that we've cited to saying, and Bumble will agree to anything that's reasonable. We would have agreed to anything that was reasonable. We were never asked. The next thing we heard was, we're going to file a bankruptcy petition to force the landlord's hand. We recognize it's a drastic measure, but the landlord is withholding its consent. And that was the point at which Bumble realized we are not going to get a decision on this within any reasonable time frame. And of course, we didn't.
So in your mind, once that the main lease, the main lease provision, which says about the 30 days, you either approve or disapprove, and if you don't do anything in 30 days, it's approved. In your mind, your intent was, your intent, or at least the party's intent, that once that 30 days expires, you're going to be given a written lease. You're going to be given a written sublease to enter into, right? And that's the end of it, right? That was in your mind, and that it was not going to be dragged out for 30, 40, 60, however many days that the appellant is arguing for.
That's exactly right, Your Honor. The lease said 30 days. It was expressly incorporated into the proposed sublease.
Whatever
That's
problem,
it. We're going to know.
Yeah, and whatever problem the appellant had with the landlord, that's the appellant's problem. That's not your problem.
Exactly right, Your Honor.
Okay. Anything else?
Unless the court has questions, I have nothing further.
Thank you so much. Counsel, you have 1 minute.
Thank you, Your Honors. Just to point out, we're here on appeal of a summary judgment decision, and the case law makes abundantly clear that in a case like this where a court finds that a certain contractual provision is ambiguous, then it must rely on sufficient extrinsic and objective evidence to resolve the ambiguity as a matter of law. But that isn't what the court did here. Instead, the lower court essentially read language into the lease and sublease that the parties never contemplated or agreed to or even considered.
Counsel, I've looked
What language are you thinking that the lower court read into the lease? What language are you thinking it read in?
It essentially inserted its own time is of the essence provision for respondent and saying that what this amount of time is unreasonable.
How is it, if it says 30 days, how is that ambiguous?
The record reflects that neither party anticipated that the landlord would come back with anything but an approval or a denial. And so in this case where it is
I find it really hard for that to listen to that statement, because the only party who had a relationship with the landlord was your client. The subtenant did not have a relationship with the landlord, so the subtenant had no idea what the landlord would do in this situation. They were dealing with your client, not the owner of the building.
That is correct, but the record reflects, and the affirmation of Mr. Boudreau, who is counsel for appellant, reflects that he was constantly keeping respondent's counsel in the loop, even after that request for additional information.
I would absolutely disagree with you there, because the record shows repeated attempts by plaintiff's counsel to receive updates where there was no response whatsoever from L&L's counsel. And at the point where there is a response, nothing that I saw said, we have a problem because of the NDA. Are you willing, one, and two, are you willing to waive it? This is the deal breaker here.
Mr. Boudreau submitted an affirmation that attested to the oral conversations that he had over the phone with counsel that weren't necessarily reflected in those emails that you're referring to.
How convenient. Thank you.
Thank you.